Our next witness is attorney Karen Winner. Ms. Winner.
Good morning, distinguished panel members. Good morning, audience members. My name is Karen Winner. I'm a New York attorney, and for years I've had a deep interest in how legal consumers are affected by the secrecy surrounding the discipline of lawyers. Before I became a lawyer, I wrote a report more than 20 years ago for the New York City Department of Consumer Affairs. Mark Green was a commissioner. Women in Divorce, Lawyers' Ethics, Fees, and Fairness. And it found that the public is not protected from dangerous lawyers. I drafted the Client Bill of Rights that divorce lawyers are now required to give their clients. For decades, it's been publicly known that the New York lawyer disciplinary system fails to protect consumers from unscrupulous or incompetent attorneys. We know that the New York system is too secret and metes out inconsistent discipline due to regional practices. And we also know that the system is being held captive to vested interests of lawyers who don't want any changes to the status quo. Consumers have no way of knowing which lawyers are being investigated for serious misconduct. This secrecy leaves consumers vulnerable to financial predators with law licenses. What are the ramifications to the secrecy? Because the client is left in the dark about the lawyer's pending disciplinary matter, the unsuspecting client will go to the Office of Court Administration's website, look up the lawyer, and see no public discipline under the lawyer's name. And that client then believes he or she is perfectly safe to hire that attorney. The client does not know that the unscrupulous lawyer can keep practicing all the way up until the very end of the process, and that can take years. And that whole process remains secret. So what happens when a client unknowingly hires an unscrupulous attorney who has serious allegations pending? That unsuspecting client hires the lawyer, and then the trouble begins. The lawyer won't return calls, or drags out the case with unnecessary motions, or won't follow the client's objectives, or starts engaging in myriad forms of fee abuse, like fee padding when fraudulent charges are added to the bill. These are real problems, and they're ethics violations. The client becomes concerned, starts to lose confidence in the attorney, and then finally the client has to terminate the attorney for the client's own best interest. Especially in divorce proceedings, where I'm most familiar, there's another ramification. Changing attorneys carries a stigma. The opposing lawyer will invariably use it as a tactic with the judge, that the client who changes attorneys is a difficult client. The judge has no way of knowing, due to the secrecy, that the client was victimized and terminated the lawyer for his or her own self-interest. Even the judge has no way of knowing that the discharged lawyer is under investigation. Secondly, the client who has had to terminate his or her relationship with an unscrupulous lawyer has wasted the client's financial investment, and a new lawyer has to be hired, and the client has to start all over again with no recompense for the lost money. Why should lawyers have special protections when they are under investigation? Business people don't. The average citizen doesn't. If the New York disciplinary system would lift the secrecy and allow the public to see the complaint histories lodged against a particular attorney, maybe clients wouldn't need to change attorneys so often, because they would have the opportunity to be informed and know who has a record. The client would know how to protect him or herself before it's too late. And publishing the reported complaint histories while they're pending would protect honest attorneys, because the whole system is affected. The profession is being tainted, and honest attorneys are being tainted. Here's some solutions. There should be a consumer alert to warn consumers against lawyers who are under investigation for major misappropriation of funds. Abolish the gag rules that prevent people from speaking publicly about the complaints they've filed. Disclose a lawyer's disciplinary history so the public can be informed, including private admonitions. Open the hearings to the public, just the way they're opened in criminal and civil proceedings. It'll take courage and leadership to institute these reforms. There are powerful interests, as everyone knows, who will urge the leaders to maintain secrecy. But the public's safety should come first. Thank you.
Thank you for your testimony. I have two related questions on
Yes.
this issue of openness. First of all, you referred to criminal proceedings and the fact that they are open. We are reminded that the reason for openness of criminal proceedings was, and has been for hundreds of years, and is in our Constitution, to protect the accused person from secret proceedings. So the analogy with the professional discipline proceedings, some say, is not exactly apt. And so relatedly, I would ask you, if you are an individual practitioner doing your best to practice honorably, you're a very competent lawyer, and as often happens, you have a dispute with a client, and the client makes a complaint to the disciplinary committee and says things which, in your judgment, are they're just totally wrong or a total distortion. Is it your view that at that point the public should have access to that complaint? And would you not be concerned that the lawyer is not, and the lawyer's profession is being unfairly interfered with?
I think, there are already states that do what they already have open records. I spoke to West Virginia's disciplinary personnel a few days ago, and they gave me the statistics showing the closed complaints, including meritless complaints, and all the others. And the lawyers in West Virginia aren't having any problem with it. It's the same in Florida, and it's the same in Oregon. And so I think this is I think this is a real worry of lawyers, but I think it is a real worry, but that is really kind of contemptuous of the public. You know why? Because most people who bring complaints are very serious and sincere, just like most people that bring allegations in criminal court. And to separate those people and say, oh yeah, they're just trying to retaliate because they don't like how it happened, they don't like how the case turned out, is really not doing justice to the American people. They deserve, more, better thinking about them.
I think you suggested that there's perhaps a pattern of recidivism that happens with respect to the lawyers who are under investigation. Is that a fair summary of what you're saying? That a lawyer who's under investigation is more likely to be one who is committing further ethical violations while that attorney is under investigation. Is that the claim you're making?
Yes, anecdotally, I've been receiving.
So my question
Yes,
becomes, okay, with the number of complaints that we have in this state, is there any empirical evidence to support the fact that once an attorney has a complaint filed against him or her, that during the course of that investigation, that attorney is then committing further ethical violations, jeopardizing other litigants?
What I can tell you is that I've been receiving complaints about attorney. I wrote a book, a national expose about this, 1996, Divorced from Justice, published by HarperCollins, and I've received complaints for over 20 years about attorneys, and there have always been multiple complaints about certain attorneys, and when there's just one complaint about an attorney, it seems like an aberration, but when there are multiple complaints about attorneys.
I'm asking you, you're sort of an academic, I'll say. You've written a paper, you've written a book, okay? And I'm asking you, in the course of your study of this issue, which apparently is going on 20 years, have you accumulated empirical data to support the suggestion that while an attorney is under investigation, that attorney is then committing other ethical violations involving other clients?
Well, that's a really good question, and I don't know if any researchers can answer that empirically because the system is secret.
Yes! If the first complaint is founded, and then another complaint is filed, and that complaint is founded, you'd be able to match up the date of the filing of the first complaint, which was founded, and then if the second complaint or third complaint was founded, you'd be able to match up those dates, and you'd be able to establish that during the course of an investigation, there were indeed further violations. I'm just asking, have you done that study, or do you know of any such studies?
I can't do it because it's secret. We don't know about the investigations. But I can tell you something. Because of the way the system is set up, lawyers will retire. I've had situations where a complaint has been made, and pending that, the lawyer will retire, and then there'll be other complaints that come up, but then they won't be investigated because the lawyer retires. And I helped a family from India recover $70,000 in funds because their lawyer stole from the settlement agreement when the father was killed in a temple, and the lawyer, in a wrongful death award, stole part of the money from the widow and the children. And that lawyer retired, and there were other complaints pending, and they never saw the light of day. And I think this is a serious problem. And I don't mean to sound strident.
Thank you very much, Francesca.
You're welcome.